In this lecture, we shall discuss the venue and transfer of proceedings. And we shall have this lecture within the context of the civil procedure rules in Ghana. Venue and transfer of proceedings. Now, the reason this topic is important is because when a plaintiff intends to commence a civil action in Ghana, the plaintiff can indeed decide the venue where the action shall be commenced at. But the High Court Civil Procedure Rules 2004 CI 47 has made specific rules that are supposed to regulate the venue and transfer of civil proceedings in Ghana. Now, bear in mind, there's a High Court in Accra, High Court in Kumasi, High Courts in Tamale. There are High Courts spread across the length and breadth of the country. Now, if you want to commence an action, how do you determine the venue of the proceedings? The instructive provision to look at is Order 3 of the CI 47, and it deals with venue and transfer of proceedings. Order 3 reads as follows, and I quote, "Every cause or matter that relates to immovable property or any interest in it or for any damage to it shall be commenced in the region in which the immovable property or any part of it is situated. Every cause or matter that relates to immovable property or any interest in it or for any damage to it shall be commenced in the region in which the immovable property or any part of it is situated." Order 3, Rule 2. Order 3, Rule 1, Sub Rule 2. Every cause or matter that relates to movable property, distrained or seized for any cause shall be commenced in the region in which the distraint or seizure takes place. Again, every cause or matter that relates to movable property, which has been distrained or seized for any cause shall be commenced in the region in which the distraint or seizure takes place. And then every cause or matter against a public officer to recover penalty or forfeiture shall be commenced in the region where the cause of action arises. Every cause or matter against a public officer to recover penalty or forfeiture shall be commenced in the region where the cause of action arises. Then every cause or matter for specific performance of a contract or in respect of breach of contracts shall be commenced in the region in which the contract ought to have been performed or in which the defendant resides or carries on business. Let me take that one again. Every cause or matter for specific performance of a contract or in respect of a breach of contracts shall be commenced in the region in which the contract ought to have been performed or in which the defendant resides or carries on business. And then all other causes or matters shall be commenced in the region in which the defendant resides or carries on business. Now let me explain the one that relates to specific performance and also explain the one that relates to the other matters. If it's for specific performance of a contract or in respect of a breach of contracts, then the region where you shall commence the action is the region where the contract ought to have been performed, or the region where the defendant resides or carries on business. So if you want to sue a person for breach of contract, then where you commence the action, it must be the region where the contract ought to have been performed, or the region where the defendant resides or carries on business. So you have two options. So either you go to the region where the contract ought to have been performed, or the region where the defendant resides or carries on business. But what if it's a matter that doesn't fall under any of the ones we've mentioned? Because we mentioned one that relates to immovable property, that you go to the region where the property is situated. Movable, where the restraint or seizure took place. A cause or matter against a public officer to recover penalty. We say that you shall commence it in the region where the cause of action arises. If it's for specific performance, what did we say? In the region where the contract ought to have been performed, or in which the defendant resides or carries on business. What if the matter that you have, it doesn't fall under any of these? We are told that all other causes or matters shall be commenced in the region in which the defendant resides or carries on business. So if it's a matter that has not been specifically provided for under any of the other three that you are saying, Rule 1, Sub 1 to 4. If it's not about land, it's not about movable, it's not about public officer, it's not about specific performance or a contract, then you shall commence the action in the region that the defendant resides or carries on business. Why is this so? You, the plaintiff, you are the one going to commence the action against the defendant. So you, the plaintiff, you can't live in Accra. And then when the defendant is residing in Tamale, you go and sue the defendant in Accra court and expect the defendant to come to Accra. It won't work. Or you're a plaintiff living in Boku. Then as living in Boku, that you want to sue me, a defendant residing in La in Accra. You sue me in the high court in Boku. It won't make sense. That's why we are told that all other causes or matters shall be commenced in the region that the defendant resides or carries on business. So if you want to bring an action against somebody, since you are the one commencing the action, if you are living in Accra, where the defendant resides, if the defendant resides in Swedu, then you must commence the action in the region where the defendant resides or carries on business. In other words, it must be something that is more convenient for the defendant, because you, the plaintiff, you are the one bringing him to court. What if you want to bring an action against two defendants or three defendants? One is in the eastern region, one is in Greater Accra, one is in the central region. We are told that if there are two or more defendants resident in different regions, the cause or matter may be commenced in any of the regions. So these are the rules that regulate the particular venue where we must commence our actions at. Now, what if the action is commenced in the wrong venue? For example, when the action ought to have been commenced in Accra, then the action is rather commenced in the central region. What transpires? What shall be the outcome? Order 3, Rule 2, Sub 1 has the answer, and this is what it says. Now, before I read it, please pay particular attention to the portions that have been highlighted. Order 3, Rule 2, Sub 1 reads as follows. Order 3, Rule 2, Sub 1 of the CI 47 reads as follows, and I quote: where a cause or matter is commenced in a region other than in which it ought to have been commenced under the rules, it may continue in the region in which it was commenced. Emphasis: it may continue in the region in which it was commenced. Emphasis: it may continue in the region in which it was commenced. In other words, where a cause or matter is commenced in the region other than where it ought to have been commenced, it may continue in the region in which it was commenced unless A, the defendant raises an objection to the jurisdiction before or at the time the defendant is required to file a defense in the proceedings. Now, this part is very critical. It says that unless the defendant raises an objection, look at the timeline for the objection. Please do not forget the timeline. The timeline is that you raise an objection to the jurisdiction before or at the time the defendant is required to file a defense in the proceedings, or the court reports to the Chief Justice that in its opinion, the proceedings ought to be transferred, and the Chief Justice orders the transfer of the case. So take note of the language of Order 3 Rule 2. It says that if you commence the action in a region other than where it ought to have been commenced, two things can happen. The action may continue in that region. So for example, if the land is in Accra and they've sued the defendant in Ho, the action can continue in that region unless the defendant raises an objection to the jurisdiction. But the Act gives you the timeline for raising the objection. It says before or at the time the defendant is required to file a defense in the proceedings, or the court reports to the Chief Justice that in its opinion, the proceedings ought to be transferred, and the Chief Justice orders the transfer. So if you are asked, at what point in time do you raise an objection? Before or at the time the defendant is required to file a defense? And very soon you understand why I'm emphasizing on this point. Because if you have filed your defense, you'll be deemed to have waived your right to now object to the venue. And therefore, the court can proceed to hear the matter on the merits, and whatever judgment they give will be a judgment of the High Courts. I'll explain that shortly. So please don't forget the timeline for raising the objection. It is before or at the time the defendant is required to file a defense in the proceedings, or the court on its own, the court reports to the Chief Justice that in its opinion, the proceedings ought to be transferred, and the Chief Justice orders the transfer of the suits. Now, I have mentioned that under Order 3 Rule 1, there are different regions in which an action can be commenced. I have also mentioned that if you commence an action in the wrong venue, it shall continue in that wrong venue unless the defendant raises an objection to the jurisdiction before or at the time the defendant is required to file a defense, or the court on its own motion reports to the Chief Justice that the suit to be transferred. Now, my question is this: what after the suit has been transferred, so that, for example, after you commence the action, you obtain an injunction before the defendant raised an objection and the suit was ultimately transferred? What happens to all the proceedings taken before the transfer of the suit? The suit was in Ho, the court made some orders. Subsequently, there has been a transfer to Accra. What becomes of all those proceedings that were taken before the suit were transferred? Would those proceedings be valid? Would they be void? What would be the effect? Because think about it. The action was commenced in the wrong forum. Now it's been transferred to the right forum. So the court was initially Ho, now it's been brought to Accra. The High Court in Accra, when it assumed jurisdiction, what will become of all those orders that were given before the transfer was made? The answer is under 3 Rule 2, Sub Rule 2 of the CI 47. And it reads as follows, and I quote: no proceedings taken prior to an objection to the jurisdiction with regard to venue raised by the defendant under paragraph A of Sub Rule 1 of this rule shall be affected by the objection. By the courts, if satisfied that the objection is well-founded, shall inform the Chief Justice that in its opinion, the cause or matter ought to be transferred to the region in which it ought to have been commenced. And the Chief Justice may upon that make that order as the Chief Justice considers appropriate. In other words, take note of the opening sentence. It says that no proceedings taken prior to the objection to the jurisdiction with regard to venue shall be affected by the objection. It means that whatever proceedings have already happened, they shall continue to remain valid. So please, if an action is commenced in the wrong forum, if you begin practicing and you notice that the land is in Accra, but the suit have been commenced in the central region, you do not apply for the suit to be struck out. No. You don't apply for the suit to be struck out. You apply and then let the court report to the Chief Justice for the suit to be transferred to the wrongful, but you don't apply for the whole suit to be struck out. And very soon you understand why you don't report for the suit to be, you don't apply for the suit to be struck out. Like I'm saying, what you do is that you object, let the court report to the Chief Justice for the suit to be transferred. And the reason I keep emphasizing Chief Justice is because under Section 1041 of the Court Acts of 1993, Act 459, it is only the Chief Justice that is given the power to transfer suits. So for that reason, let me read what Article 104, subsection 1 of the Court Act says. Section 104, subsection 1 of the Court Act, 1993, Act 459, and it says as follows, and I quote, subject to the Constitution, the Chief Justice may, by order signed by the Chief Justice, transfer a case from a judge or magistrate or tribunal to any other judge or magistrate, and from one court to any other competent court, at any time or stage in the course of proceedings, and either with or without an application from any of the parties to the proceedings. Section 104 demonstrates the enormous power the Chief Justice has. Take a critical look at it. It says that the Chief Justice may, by order signed by the Chief Justice, transfer a case from a judge to any other judge or magistrate, and from one court to any other court of competent jurisdiction at any time. So the CJ can transfer the case at any time or stage in the proceedings. And in fact, the CJ can transfer even with or without an application from any of the parties to the proceedings. So the CJ thinks that this case should be transferred, it can transfer the case even when no party has brought any application requesting for that. Now, Section 104, subsection 3 has very interesting provisions. Section 104, subsection 3 of the Court Acts of 1993, Act 459. It reads as follows, and I quote, a transfer of a case made by telegraph, telephone, or electronic communication, and not confirmed immediately by order, signed and sealed in a manner specified by the Chief Justice or any other person authorized in that behalf by the Chief Justice is not valid. A transfer of a case made by telegraph, telephone, or electronic communication and not confirmed immediately by order signed and sealed in a manner specified by the Chief Justice or any other person authorized in that behalf by the Chief Justice is not valid. So if you read this in conjunction with 104 subsection 1, we are told that the Chief Justice may, by order signed by the Chief Justice. So for the transfer of the case, it's supposed to be triggered by the CG by an order signed by the Chief Justice. So if we now come and say that a transfer of a case made by telegraph, we have been told that the transfer of the case must be by an order signed by the Chief Justice. And that is why we are told that if a transfer is made by telegraph, telephone, or any other electronic communication, and is not confirmed immediately by order, signed and sealed in a manner specified by the Chief Justice, then that transfer would become void or not valid. Now, remember I mentioned that if it comes to the transfer, the judge's own motion can even report to the Chief Justice and request for a case to be transferred. Now, this provision that we saw under order 3, we have a similar provision under section 105, subsection 1 of the Court Act of 1993, Act 459, and it reads as follows, and I quote, a justice of the High Court or chairman of a regional tribunal may, on the initiative of the justice or chairman, or on an application by a person concerned. So you see, either the justice of the High Court or chairman of the regional tribunal may, on the initiative of the justice, so on the judge's own initiative, or on an application by a person concerned, he may report to the Chief Justice a case civil or criminal pending before the justice or chairman, which in the opinion of the justice or chairman ought for any reason to be transferred to any other court, justice or regional tribunal. In other words, the judge hearing a matter on your own initiative, you can report to the Chief Justice that this case pending before me, this case ought to be transferred to any other court, justice or tribunal. So remember we saw under Order 3 that Order 3 Rule 2 1B that the court on its own can report to the Chief Justice that in its opinion the proceedings ought to be transferred. In that same vein, we've seen under Section 105, subsection 1 of the Court Act, that the justice of the High Court hearing a case may, on the initiative of that justice or chairman, report to the Chief Justice a case or civil or criminal matter pending before the justice, which in the opinion of the justice ought to be transferred to any other courts. So Section 1051 of the Court Act allows the justice to also report to the Chief Justice for the suit to be transferred. Section 105, subsection 2, it provides that where the Chief Justice is satisfied that a transfer is desirable, then the Chief Justice shall specify the court or tribunal to which, or the justice to whom that case is to be transferred for hearing and determination, and shall give the necessary directions. So where the Chief Justice is satisfied that a transfer is desirable, the Chief Justice shall specify the court or tribunal to which, or the justice to whom that case is to be transferred for hearing and determination, and shall give the necessary directions. I asked the question and I mentioned that I'll answer it shortly. The why is it that an action commenced in the wrong venue will not be a nullity? Why is it that if the land is in Accra and the defendant plaintiff sues in Central Region, why can you not apply to strike out the whole suits? But you rather apply for the suit to be transferred. Why would you not apply and say that the rules provide that if it's a land matter, it must be in Accra? So if you brought it in the Central Region, your whole suit is a nullity. Why is that so? It will not be a nullity because there's only one high court in Ghana, and we shall explain that shortly. Look at the language of Article 126, Clause 1 of the 1992 Constitution. Article 126, Clause 1 of the 1992 Constitution. It reads as follows, and I quote, "The judiciary shall consist of A, the Superior Court of Judicature, comprising I, the Supreme Court, II, the Court of Appeal, and III, the High Court." Emphasis, the High Court. The High Court doesn't have an S at the end. It is a singular. It's in the singular form. The High Court and regional tribunals. It means that from our Constitution, from the language and tenor of Article 126 of the Constitution, there is only what? One High Court, because it says the High Court. So if you go to the High Court complex in Accra, you see several courts. Land Court 1, Land Court 2, Land Court 3, all the way up to about Land Court 11 or 12. You see Criminal Court 1, Criminal Court 2, Criminal Court 3. You see Commercial Court 1, Commercial Court 2. These ones, the question is that why are we still saying there's only one High Court? Because there's a High Court in Accra, there's a High Court at Adenta, there's a High Court in Tema, there's a High Court at Amasaman, there's a High Court in the Western Region, in the Central Region, in the Ashanti Region. So why are we saying there's one High Court? We are saying so because if you read the language of the Constitution, the expression High Court is preceded by the article "the," meaning there is only one High Court, the High Court. And this position is supported by settled case law. Look at this case of Yortuho versus Braco. Yortuho is spelled Yortuhor, Yortuhor. Yortuho versus Braco. Braco is spelled Brako. And another, reported in 1989-1990, 2 Ghana Law Report at page 429. Look at holding 2 in the headnotes, and it reads as follows, and I quote, By the time I finish reading the dictum in this case, it should let you understand why I'm saying there's only one high court. So because there's only one high court, if I sue you in the central region, but the land is in Accra, you can't apply for the suit to be struck out because that high court in the central region, it technically has jurisdiction because there's only one high court. So you can't say that it is a nullity. You can't say it is void because that high court technically has jurisdiction. And I'll show you why you are saying that one. But bear in mind, under Article 126, from the language over there, there's only one high court. This what was held in Yotu Hall versus Braco and another. Reported in 1989-1990, 2 Ghana Law Reports at page 429, holding two as follows, and I quote. The legislator recognized the existence of regions in Ghana and intended that actions be commenced in the appropriate region, failing which Rule 1A permitted either the court itself or the defendant to oust the territorial jurisdiction of the High Court in that particular region where the action was wrongly commenced, and thus deprived it of the power to hear the suit. Those provisions were mandatory and were meant to be complied with, and no judicial discretion arose when the defendant timelessly raised an objection to the court's territorial jurisdiction. However, under Rule 1.8, jurisdiction might be conferred on the High Court by acquiescence, even through silence by the court and the defendants. But whereas in the instant case, the defendant had raised an objection at the right moment, the court had no jurisdiction, and the suit must and could be transferred for hearing de novo before the High Court, Kumasi, i.e. the region where the defendant resided and carried on business. Now, the portion I want you to focus on over here is this, that jurisdiction might be conferred on the High Court by acquiescence, even through silence by the court and the defendants, so that you, the defendants, if the action is commenced in the wrong forum, and then you don't object, you allow the suit to go on to its finality, and the court gives judgments, that judgment will become binding. The only problem is when you raise an objection. That is when it is supposed to be transferred. But if you don't raise an objection, then if the court proceeds to hear the matter, the decision they give will become binding. Even though the land is not Accra, if it's the High Court in Wo, if you didn't object and they give a judgment, that judgment will become binding on all the parties because there's only one High Court. And so the High Court in Wo that had the matter technically had jurisdiction. Look at this case of Wiredu and another versus Mim Timber. Wiredu is spelled W-I-R-E-D-U and another versus Mim, M-I-M, Timber Company Limited. Reported in 1963, 2 Ghana Law Reports at page 167. Holding 3 of the head notes reads as follows, and I quote. The High Court was just one High Court exercising jurisdiction throughout the country. It was divided into judicial divisions merely for the convenient administration of justice, but not for the purposes of limiting the jurisdiction of each judicial division to only matters arising within its division. Again, the High Court was just one High Court exercising jurisdiction throughout the country. It was divided into judicial divisions merely for the convenient administration of justice, but not for the purpose of limiting the jurisdiction of each judicial division to only matters arising within its division. Thus, a decision of a judicial division seized with a case which could have been properly instituted in another division could be valid unless at the trial an objection was raised either by a party to the proceedings or the judge himself. Since no objection was raised at the concessions inquiry, the jurisdiction of the concession court could not be challenged, and the plaintiff's concession was in accordance with the concession ordinance, good and then valid. Now, what do we get from this case? Remember I mentioned that in Accra, when you go to the High Court complex, there's Land Court 1, Land Court 2, Land Court 3, Land Court 4, Land Court 5, Commercial Court 1, Commercial Court 2, there's General Jurisdiction 1, there's Divorce and Matrimonial. There are several courts in Accra. And I mentioned that there's a court at Adenta at Amasaman. and several places. Within the constitutional framework, they are all just divisions of just one high court. So there's only one high court, but they are all divisions, and it's just for the convenient administration of justice. We didn't divide them in order to limit their jurisdiction. No, we divided them because one high court cannot be everywhere in Ghana. So let's divide them for just administrative convenience. But technically, they are all just one high court, and they just been divided for administrative convenience. And so sometimes you will see one high court in Accra saying that I have seen the decision of the high court in Tema, but I'm not bound by it. I'm not bound because it's just a division of the one single high court. So they are court of coordinate jurisdiction. So you can't say that the high court in Tema gives a decision and it will, in fact, you can tell me that I'm bound by that position. No. They are court of coordinate jurisdiction. So the high court was just one high court, as we see in Wuedu versus Mim Timber. The high court was just one high court exercising jurisdiction throughout the country. It was divided into judicial divisions merely for the convenient administration of justice, but not for the purpose of limiting the jurisdiction of each judicial division to only matters arising within its division. Thus, a decision of a judicial division seized with a case which could have been properly brought in another division could be valid. So the decision will be valid unless at the trial an objection was raised by either a party to the proceedings or the judge himself. So like I said, remember under Article 126, there's only one high court. And as we've seen in Ruedo versus Mim Timber, it's been divided only for the administrative convenience, but not because we want to limit their jurisdiction. Now I've asked. Now we know that if you look at the language of Order 3, it talks about commencing the action in the region. I don't know whether you noticed this. Look at Order 301. It says every cause or matter that relates to immovable property or any interest in it shall be commenced in the region. If you talk about movable, in the region. Public officer, in the region. So the focus is that you must commence it in the region where the rules is directing you to. But I have a very critical question. Greater Accra region. Let's say you want to sue a defendant, and the land is Allah. Now, in the Greater Accra region itself, there are several high courts. In the Greater Accra region, there's a high court at Amasaman. There's a high court at Adenta. There's a high court at Accra. So if we say that it might be commenced in the region, when you have more than one high court in a particular region, how do you take a decision on where you commence the action at? And let me use Accra again as an example. Let's say a land is at Amasaman, and the defendant is also living around Amasaman. Now, can the plaintiff decide to bring an action at the high court in Adenta and say that, my lord, the land is at Amasaman, and Order 3, I can bring the action in the region where the land is situated. Where is the land over here? Amasaman. Is Amasaman in the Greater Accra region? Yes. So Adenta court, you have jurisdiction. Meanwhile, there's a high court at Adenta. The defendant lives at Adenta. His whole family is there, and that's where he works. My plaintiff says that the High Court Civil Procedure Rule says that I must commence the action in the region. So long as I'm in the Greater Accra region, I have complied with the rules. So that's why I'm asking this question you are seeing on the screen now. That what if there's more than one high court in one region? How would the court determine which court will be the appropriate forum? The guidance to this question in terms of an answer can be gotten from the case of Volden, V-O-L-D-E-N. Volden and others versus Ghana Goldfields Limited. Volden and others versus Ghana Goldfields Limited. Reported in 1999-2000, One Ghana Law Report at page 462. These are the facts you can get from the head notes. There were two high courts in the Western region, at Sekendi and Takwa. Two high courts in the Western region, at Sekendi and Takwa. The defendant was a mining company resident at Tarkwa. The plaintiffs, former employees of the defendants, claiming to have contracted diseases in the course of their employment, brought an action against the defendant at the High Court Second D for inter alia payment of 20 months salary for each for the sickness. I want you to take note of something. There were two high courts in the Western region, Second D and Tarkwa. Take note of where the defendant's mining company was resident at. The defendant company was at Tarkwa. But the plaintiff rather brought the action at Second D. Meanwhile, the defendant company is at Tarkwa. Let's see what happened. The defendant then applied to the court to transfer the suit to the High Court Tarkwa for hearing, on the ground that all the parties and their witnesses, as well as counsel for the defendant, they resided at Tarkwa. So look at the first carefully. Two high courts in the Western region, Second D and Tarkwa. Now you, the defendant's company, you are in Tarkwa. Then the plaintiff rather went to sue at Second D. But if you think about it, they are all in the same region. That is the Western region. So the defendant mining company that was at Tarkwa applied that, let us transfer this suit from Second D to Tarkwa. On the court finding that indeed it was only counsel for the plaintiff that was at the Second D, the court held as follows: that the rationale for the creation of multiple high courts within one region was to let the parties litigate in the high court nearest to them and thereby save them time, energy, and expense. Accordingly, although no provision in the High Court Civil Procedure Rules, Amendment Rules 1977, LI 1107, governed the situation where there was more than one high court in the region with jurisdiction to hear a matter, and the defendant against whom an action had been brought in one high court applied to that court to transfer the suit to the other. It was within the discretion of the high court to determine that application. The test to be applied in each case was whether the defendant would suffer injustice if the action was heard in the court where he did not reside or carry on business. On the facts, it would be more expeditious, proper, and convenient to have the suit heard at the High Court Tarkwa, since on the balance of hardship, more hardship would be caused to the defendant than the plaintiffs if the suit was heard in the High Court Second D. Accordingly, a report will be made to the Chief Justice to exercise his power of transfer accordingly. End of quote. What do we get from this case? What we get from this case is that in this case, the defendant mining company, they are in Tarkwa. All their witnesses, they intend to rely on Tarkwa. Defendant counsel Tarkwa. The only person who resided as Second D in this case was counsel for the plaintiff. So if you are going to sue the defendant, why do you want to make it inconvenient for them to travel all the way from Tarkwa Second D? That the court realized that the test to be applied was whether the defendant would suffer injustice if the action was heard in the court where he did not reside or carry on business. So in this case, if the matter was heard at Second D, it would have been inconvenient for the defendant. But even though it's the same region, they must always travel from Tarkwa to Second D. So in this case, the court noted that hardship will be caused to the defendants. So even though it was the same region, the court ordered that the suit be transferred from Second D and that they are reporting to the Chief Justice so that we transfer to Tarkwa rather for the case to be heard. This means that even though Order 3 talks about region, if the land is Amasaman, everybody that lives at Amasaman, if there's a high court at Amasaman, why don't you commence the action over there? So this case of Golden and others versus Ghana Goldfield Limited will answer the question. So the test to be applied in this case was whether the defendant would suffer injustice if the action was heard in the court where he did not reside or carry on business. Please bear in mind this test. Do not forget this test, that the test to be applied when we are dealing in the same region and there are multiple high courts in the same region, the test to be applied was whether the defendant would suffer injustice if the action was heard in the court where he did not reside or carry on business. Let's look at this case as well. Ingo's Construction Company Limited. Ingo's Construction Company Limited versus Blackwood, B-L-A-C-K, Blackwood Hodge, Ghana Limited. Reported in 1981 Ghana Law Report at page 347. What transpired in this case? And I'll proceed to read the facts from the head notes. And I read as follows. This was an application by the defendant asking the courts for an order to transfer the substantive libel suit in this case to the High Court Accra, where the defendant's company were registered and carried on business to be heard there. The plaintiff resisted the application on the ground that by virtue of Article 124 of the 1979 Constitution, there was only one High Court of Justice, and also that in view of the fact deposed to in the accompanying affidavits, the High Court Second-D was the most convenient venue for the trial. The courts, having accepted the affidavit evidence that the libel complaint was published in Takoradi, the bank where the plaintiff had an account was at Takoradi, and the checks which gave rise to the statements complained of were issued on the Takoradi Bank, and that the manager of the bank was resident at Takoradi, and all the relevant documents of the bank were kept in Takoradi. Upon a closer look at the High Court's rules as a whole, and in particular having with regard to the Constitution, which provided that there was only one High Court, it seemed that the court before which an application was made for transfer of a suit had a discretion in the matter. The court ought to look at all the circumstances of the case and decide whether or not to transfer the suit. Every case must stand on its own peculiar facts, but the test to be applied in each case, once again, like I said, don't forget the test. The test to be applied in each case was where the defendant had applied that the matter be transferred, was whether the defendant would suffer some injustice if the action was heard in the region where he did not reside or carry on business. The defendant must be able to prove either that the expense or the difficulties of trial in that region would be so great that injustice would be done in the sense that it would be difficult or practically impossible for the litigant who was applying for the transfer to have had justice in that region, on the fact the application will be refused. So you realize from these two cases that when there is one region and there are multiple high courts in that particular region, there is a test the court will apply in determining whether to transfer the suit, order for the transfer to be made or not. The test is whether the defendant will suffer injustice if the action was heard in the courts where he did not reside or carry on business. And I've explained this already. You, the plaintiff, you are the ones suing the defendants. So if the plaintiff live in Accra and are going to sue a defendant who is resident somewhere around Amasaman, why do you want to bring the action at Tema when the defendant is Amasaman? So the test to be applied in each case was whether the defendant would suffer injustice if the action was heard in the courts where he did not reside or carry on business. And as you see in Ingo's Construction Company Limited versus Blackwood Hodge, we are told that the court that you made the application to, it has a discretion in the matter. And its discretion is going to be guided by the fact that every case stands on its own peculiar facts. And the test to be applied in this particular case was whether the defendant would suffer some injustice if the action was heard in the region where he did not reside or carry on business. Now, I remember I asked the question that what will be the validity of proceedings taken before the objection? And you remember we referred to under 3 Rule 2 that any proceeding taken prior to the objection, it shall remain valid. Remember, we look at 3 Rule 2 that no proceedings taken prior to an objection to the jurisdiction with regard to the venue shall be affected by the objection. So that 3 makes it clear that any orders made prior to the objection, those ones do continue to be what? To be valid. So all objections taken prior to the objection, those ones, they shall continue to remain valid. But what about proceedings taken after the objection? So let's say that I object that this should be reported to the CJ for same to be transferred. Let's say the land is at Accra. You sued in the central region. I said, no, this case, report to the CJ for same to be transferred. After I've objected, you refused and you still went ahead to hear the case, went ahead to grant an injunction, went ahead to now give some orders for preservation and all those manner of things. But you made all those orders after I had raised the objection. And let's say after I raised let me give a practical example. Land is in Accra. Suit is brought in the central region. I object. Transfer the case to Accra. Judge refuses that he's not going to report to the Chief Justice. Orders you to file the defense. Then you appeal against the judge's ruling to the Court of Appeal. But while the appeal is being heard, the judge at the High Court now in the central region goes ahead to now give some orders, injunction, preservation, and all these orders were made after the objection was raised. Eventually, when the suit is now transferred, what will happen to all those things? Now, before I answer this question, let me remind you that when it comes to the validity of proceedings taken before the objection, the rules are clear. Look at the language of Order 3 Rule 2 or the CI 47. It's very clear that no proceedings taken prior to an objection with regard to the venue shall be affected by the objection. So as for the proceedings taken before the objection, no two ways about it. Order 3 Rule 2 says that those ones, they shall continue to be valid. But what about proceedings taken after the objection? Over there, let's look at the cases of Yotuho versus Brackwell and another, and Wilmots and Wilmots. Yotuho versus Brackwell and another versus Wilmots and Wilmots. Now, if you remember Yotuho versus Brackwell and another, let me tell you what the court will say before I read it so that you can get a better perspective. Now, if I object to the venue and you refuse to transfer, and later on the suit has been transferred by the CJ, know that all the orders you made after the objection, those ones will be null and void. Because you did not have the jurisdiction to make those orders. Because I have objected, transfer the thing, order, report to the CJ for same to be transferred. You know the land is in Accra. You are in central region. You are hearing the case. After the objection, you made some orders. Those orders, if the suit is eventually transferred, they will all become null and void, and we must begin the trial afresh. If you remember in Yotuho versus Brackwell, remember it says that those provisions were mandatory and were meant to be complied with, and no judicial discretion arose when the defendant timelessly raised an objection to the court's territorial jurisdiction. So you see, the legislator recognized the existence of regions in Ghana and intended that actions be commenced in the appropriate region, failing which Rule 1.8 permitted either the court itself or the defendant to oust the territorial jurisdiction of the High Court in that particular region where the action was wrongly commenced, and thus deprive it of the power to hear the suits. Those provisions were mandatory and were meant to be complied with, and no judicial discretion arose when the defendant timelessly raised an objection to the court's territorial jurisdiction. What does this mean? This means that if the land is in Accra and you bring the action in the central region, once the defendant timelessly raised the objection, the court, you don't have any judicial discretion. You must stop whatever you are doing, report to the Chief Justice, and let it be transferred. Because look at what the court said in this case. But whereas in the instant case, the defendant had raised an objection at the right moment, the court had no jurisdiction, and the suit must and could be transferred for hearing de novo. De novo means for hearing afresh before the High Court Kumasi, the region where the defendant resided and carried on business. So you see, once I object at the right time, you don't have any judicial discretion to go on with the case and go and make some orders. As we've seen in Yotuho versus Brackwell and another, what have we been told? But whereas in the instant case, the defendant had raised an objection at the right moment, the court had no jurisdiction, and the suit must and could be transferred for hearing de novo before the High Court, Kumasi, the region where the defendant resided and carried on business. So like I told you, remember the question, what is the validity of the proceedings before and after the objection, leading to the transfer from one venue to the other? No two ways about it. If it's the proceedings before the objection, Order 3 Rule 2 says it shall be valid. But if it's a proceeding taken after the objection, your Tuho and Braco is saying that once I raise the objection timelessly, you don't have any jurisdiction to even go ahead. Whatever you do will be null and void, and therefore the trial must begin de novo. Look at the case also of Wilmot and Wilmot. Similar provision. It says that under the new Order 5 of so and so rules, there were two conditions under which the jurisdiction of a court where an action had been wrongly commenced could be ousted. The first was where the judge had reported the pendency of the action to the Chief Justice, and the Chief Justice had ordered a transfer. And the second was where the defendant had raised an objection to the jurisdiction of the courts before or at the time he was required to plead. In the latter instance, which is when the defendant had objected, in the latter instance, there was no discretionary power vested in the High Court to exercise. So that once the defendant had raised the objection, as required by law, the jurisdiction of the court would be ousted outright, and any purported hearing of the case would be a nullity. You see what we are getting over here? Once there's an objection to venue, you, the judge, you don't have any jurisdiction to go ahead. If you go ahead and you go and make an order, Wilmot and Wilmot is saying that whatever happened will be a nullity. So please bear in mind, like we have said so far, for proceedings that happened before the objection, they will continue to be valid. But for proceedings that happened after the objection, we've been told in Yotu Ho versus Braco, as well as Wilmot and Wilmot, that once you object, everything must stop, and you can't go ahead and give any orders. Any orders you make, they'll become null and void. And as we've seen in Yotu Ho versus Braco, the trial will have to begin de novo. Now, there's an interesting question that we have to look at. And it flows from the language of Order 3 of the CI 47. Order 3 says that if the matter is commenced in the wrong region, what happens? The defendant can raise an objection to jurisdiction. The question is that, does this really go to jurisdiction? If the land was in Accra, and then the action was commenced in Second D, when you are objecting, are you really objecting to jurisdiction? Because we've already been told that in Uredu versus Mim Timber, that there's only one high court in Ghana, and that high court technically has jurisdiction. So if we've been told that there's only one high court and you have jurisdiction, why is the rule saying that the defendant must raise an objection to the jurisdiction? What I'm saying is that we have been told in Uredu and Mim Timber, we've been told in Yotuho versus Braco, we've been told in Wilmot and Wilmot that there's only one high court in Ghana, and that high court has jurisdiction across the whole country, and that it has been divided only for administrative convenience. If that is so, why is the rule saying under Order 3 Rule 2 that the defendant must raise an objection to the jurisdiction? If we have already said that under Article 126, there's only one high court that has jurisdiction in the whole Ghana, why are we being told that the defendant must raise an objection to the jurisdiction? Now, the word jurisdiction here has been explained. So look at S. Kwame Ntete's book, Civil Procedure, a Practical Approach at page 200. This is what he says. That jurisdiction in this context means the place of trial. It is therefore improper to count an objection to venue in jurisdictional terms, as the court has jurisdiction to raise the objection. The objection may be exercised after the entry of unconditional appearance at any time before or the time the defendant is required to file a defense. Although the objection is not jurisdictional, the court will be stripped of the power to proceed in the action any further once a valid objection is raised. Again, although the objection is not jurisdictional, the court will be stripped of the power to proceed in the action any further once a valid objection is raised. It means that technically, the word jurisdiction and adultery is not jurisdiction in the sense of it being jurisdiction. It's only referring to place of trial and not jurisdiction as in the jurisdiction of the court. It's only referring to jurisdiction meaning the place of trial. So if I sue you and the land is in Accra and I sue you in the northern region, you cannot enter conditional appearance and say that you are objecting to the court's jurisdiction, because technically speaking, as we've seen, and that's 126, the court has jurisdiction to hear the matter. So if the court has jurisdiction, you can't enter conditional appearance and say you want to strike out the whole action for lack of jurisdiction. No. What you must do is to enter an unconditional appearance. And you can apply to have the case be reported to the Chief Justice for it to be transferred. But you can't say that that court lacks jurisdiction, because the jurisdiction used in order 3 means place of trial, and it doesn't mean jurisdiction of the courts. And let me go ahead. I'm still reading from S. Kwame, Civil Procedure, a Practical Approach, at page 200 and page 201. Although the objection is not jurisdictional, the court will be stripped of the power to proceed in the action any further once a valid objection is raised. The judge must uphold the objection and refer the action to the Chief Justice, failing which the defendant may apply to the Supreme Court for an order to prohibit the court from dealing any further with the matter. You can see we always mention that you must report to the Chief Justice for the transfer. Report to the Chief Justice for the transfer. Now, apart from the Chief Justice, is there any other person that can transfer a case from one court to another? Can the registrar transfer a case from one court or from one region to the other? Look at the case of Republic versus High Court, Accra, ex parte Yali, Jani, and another interested parties. In this case, it was held that nobody apart from the Chief Justice had the power to transfer. And I'll read what the court says. If anybody apart from the Chief Justice dares to transfer, that transfer will be deemed to be a nullity. And as I'll show that shortly. Republic versus High Court, Accra, ex parte Yali, Jani, Gyane, and another interested parties. This is what Mrs. Woodsage said, and I quote. Thus, once any matter as explained above has been placed before a judge, in the absence of an order of transfer from the Chief Justice or the supervising High Court judge under Section 104 or 459, as the case may be, it is only that judge who has exclusive jurisdiction to deal with the matter or any part thereof. It follows rather emphatically that no registrar, and this extends to magistrates and judges, has the power to remove matters pending before a judge or court to another judge or court without the express authorization of the Chief Justice or the supervising High Court judge or chairman of the regional tribunal, as the case may be, and in the manner prescribed under the law. Any such purported transfer by a registrar is unlawful and a complete nullity. I'll take that portion again. It rather follows emphatically that no registrar, and this extends to magistrates and judges, has the power to remove matters pending before a judge or court to another judge or court without the express authorization of the Chief Justice or the supervising High Court judge or chairman of the regional tribunal, as the case may be, and the manner subscribed by the law. Any such purported transfer by the registrar is unlawful and a complete nullity. You see, like I mentioned, if anybody apart from the Chief Justice or the supervising High Court judge transfers, the transfer will be deemed to be a nullity. Look at this case also. Republic versus High Courts, Fast Track Division, ex parte, Ghana Lotto Operators Association, NLA Interested Party. Reported in 2009 Supreme Court of Ghana Law Report at page 372. This is what the Supreme Court said. That a registrar, without an order from the Chief Justice, had no authority to transfer a case, including interlocutory applications from one court to another. If the registrar did that, the receiving judge acquired no jurisdiction, and therefore the proceedings before him would be null and void. What have we said so far under venue and transfer? What have we said so far under venue and transfer? We have said that under Order 3, the rules provide for different places where actions are supposed to be commenced at. Now, even though the rules provide for all of that, what did we say? That if you want to object as a defendant, you must object before or at the time you are required to file your defense. Or the court on its own motion can report to the Chief Justice for the transfer to be done. Which law gives the Chief Justice the power to transfer the cases? They are under Section 104 of the Courts Act of 1993 at 459. What did we learn from the case of Yotu Hall versus Braco and another? And also Ruedu and another versus Mim Timber, Volding and others when the Ghana Goldfields Limited. All these cases take the view that there's only one high court in Ghana with jurisdiction throughout the whole country, and that they've been divided only for administrative convenience. What did we get from Yotu Hall versus Braco and another? And then Womot and Womot? We're told that even though the court has jurisdiction, once an objection is raised to the venue, the court has no power to go ahead. And if they dare go ahead, whatever they do will become null and then void. And then, apart from the Chief Justice, that's the power to transfer. Who else has the power to transfer cases? Bear in mind, as we've seen in Republic versus High Court Accra, ex parte Yale, Jenny, and another interested parties. What do we get from that case? That it is only the Chief Justice or the supervising High Court judge that has the power to transfer a case from one court to another. If any other person, like a registrar, magistrate transfers, the transfer will be deemed to be null and void. Finally, what becomes of the proceedings that happened before the objection and the ones that happened after? Remember, if it is before the objection, Order 3 Rule 2 says that no proceedings taken before the objection shall be affected by the transfer. So anything done before the objection will be valid. But if I object and you refuse to transfer, and then you still go ahead and make some orders, remember what we saw in Yotu Hall versus Braco. Remember what we said in Womot and Womot, that once an objection is raised timelessly, no judicial discretion arose. And then everything that transpired after the objection will be deemed to be null and then void. This will be the end of our lecture on venue and transfer as provided for under Order 3 of CI 47. Thank you.